Legal aspects of investigations, evidence types. Evidence and appropriate methods for handling evidence are a critical legal issue. Some evidence carries more weight than others, but security professionals should always attempt to provide all evidence, and they have to know what all the rules of the evidence are. The basic evidence types are real evidence, so that's like literally, like a bloody glove or a knife or some other physical object. In the case of computer crimes, it could be a DVD or a USB drive or some sort of printed business record that came from a computer, obviously. Direct evidence is testimony from a witness who heard or saw something through one of their five senses. Circumstantial evidence lets you make assumptions about other evidence through indirect proof. So, as an example, like if you find source code for malware on someone's computer, that would be circumstantial evidence that they're distributing or making malware. It's hard to say, corroborative evidence. It supports other facts that have come to light, but it's not the actual specific evidence. I'm actually not 100% sure on this one. So if you have a comment you want to define corroborative evidence for me, that would be awesome. And the same goes for hearsay evidence. I get what hearsay is in general, but as regards to computer cases, I've done a fair amount of Googling and not finding the clearest answers, and maybe I'm just not picking that up. So then we have the best evidence rule, which is refers to what courts prefer. So courts like original documents versus copies. They like tangible objects versus oral testimony. And the five criteria for best evidence is relevant, authentic, accurate, complete, and convincing. And secondary evidence is the last one. And with computers, it might be hard to obtain best evidence. So you can use things like logs as secondary evidence. So it might not actually be the first-hand evidence, but it might be valid in courts.